Dear students, welcome back to your education channel Learn and Educate, where we were studying Code of Civil Procedure 1908, under which Section 132 under the Part 11 Miscellaneous. Section 132 states about exemptions of certain women from personal appearance. Subsection 1. Women who, according to the customs and manners of the country, ought not to be compelled to appear in public shall be exempt from personal appearance in court. Women, as per the customs and the manners of the country, who is not compelled to appear in the public, shall be exempted from personal appearance in court. Section 132 subsection 2 states about nothing contained herein in section 132 shall deemed to exempt such woman from arrest in execution of a civil process in any case in which the arrest of the woman is not prohibited by this court. Nothing in this section shall herein contained shall be deemed to exempt a woman from against whom arrest in execution of a civil process in any case in which the arrest of woman is not prohibited by this court, where exemption of certain women from personal appearance would not apply for arrest of a woman from in execution of a civil process. Section 133 states about exemption of other persons. Subsection 1. Following persons shall be entitled to exemption from personal appearance in a court, namely the President of India, the Vice President of India, the Speaker of the House of People, the Ministers of the Union, the President of India, the Vice President of India, the Speaker of Parliament, the Ministers of the Union, the Judge of the Supreme Court, the Judges of Supreme Court, the Governors of a State and the Administrators of Union Territory, the Governors of State and the Administrator in the same of the Union Territories, the Speaker of the State Legislative Assembly, the Chairman of the State Legislative Councils. In the similar manner, President of India, Vice President of India, the Governor of the State and the Administrator of Union Territory, the Judges of the Supreme Court, the Minister of the Unions, the Speaker of the House of Parliament, the Speaker of the House of Parliaments, the Speaker of the State Legislative Assemblies, the Chairman of State Legislative Councils, the Ministers of the State, the Judges of the High Courts, the Minister of States, the Judges of the Supreme Courts, the Judges of High Courts, and the person to whom Section 87B applies, and the person to whom Section 87B applies. Section 87B states about application of Section suit against the rulers or former Indian states. Section 87B states about application of Section 85 and 86 to former rulers of Indian state. Application of Section 85 and 86 to the rulers of former Indian state, where Section 85 states about persons specifically appointed by the government to prosecute or defend on behalf of foreign rulers. Person specifically appointed by the government to prosecute or defend on behalf of foreign rulers. 1. Subsection 1. The central government may, at the request of the ruler of a foreign state or at the request of any person competent in the opinion of the central government, to act on behalf of such ruler by an order, appoint any persons to prosecute or defend any suit on behalf of such rulers, and any person so appointed shall be deemed to be the recognized agents by whom appearances, acts, and applications under this code may be made or done on behalf of such ruler. Subsection 2. An appointment under this section may be made for the purpose of a specified suit or of several specified suits. An appointment under section 85 shall be made for the purpose of a specified suits or several specified suits, or for the purpose of all such suits as it may from time to time be necessary to prosecute or defend on behalf of such ruler. Subsection 3. A person who is appointed under this section may authorize or appoint any other person to whom appearances and applications and to do such acts in such suits as if he were himself a party thereto. The analysis of Section 85 is that the central government will appoint a competent person to prosecute or defend any such suits on behalf of foreign rulers at the request of such ruler of a foreign state by an order. An appointment under this section may be made for the purpose of a specified suit or several specified suits. A person appointed under this section may authorize or appoint any other persons to make appearances and applications. Section 86 states about suits against foreign rulers, ambassadors, and envies. Subsection 1. No foreign state may be sued in any court otherwise competent to try the suit except with the consent of the central government certified in writing by secretary to that government, provided that the person may, as a tenant of immovable property, sue without such consent as aforesaid a foreign state from whom he holds or claims to hold the property. Subsection 2 of Section 86 states about such consent may be given with respect to specified suit or to several specified suits or with respect to all suits of any specified class or classes, and specify in case of any suits of or class of suits the court in which the foreign state may be sued, but it shall not be given unless it appears to the central government that the foreign state A has instituted a suit in the court against the person desiring to sue it, or by itself or another trades within the local limits of the jurisdiction of the court, or C is in the possession of immovable property suitable within those local limits and is to be sued with reference to such property or for money charged thereon, or has expressly or impliedly waived the privileges accorded to it by this section. Subsection 3 states about except with the consent of the central government certified in writing by the secretary to that government, no decree shall be executed against the property of such foreign state. Subsection 4 the preceding provisions of these sections shall apply in relation to any ruler of a foreign state, any ambassador or envoy of a foreign state, any high commissioner of a commonwealth country, any high commissioner of a commonwealth country, and C any such member of the staff of the foreign state or the staff to reunite to return the ambassador or envoy of a foreign state or of the high commissioner of a commonwealth country, as the central government may by general or specific order specify in this behalf as they apply in relation to a foreign state. Subsection 5 states about the following persons shall not be arrested under this code, namely the ruler of any foreign state, in the same manner as Section 133 applies, the ruler of any foreign state; B. Any ambassador or envoy of a foreign state; C. Any high commissioner of a commonwealth country; D. Any such member of the staff of a foreign state or staff or retain of a ruler, ambassador, or envoy of a foreign state, or of the high commissioner of a commonwealth country, as the central government may, by general or special order, specify in this behalf. Subsection 6 of Section 86 states where a request is made to the central government for the grant of a consent referred to in subsection 1, the central government shall, before refusing to accede to the request in whole or in part, give to the persons making the request a reasonable opportunity of being heard. Analysis of Section 86 is that 1. Only with the consent of the central government, any foreign state can be sued in any court competent to try the suit, certified in writing by a secretary to that government, provided that person may, as a tenant of the immovable property, sue without such consent when such foreign state claims to hold the property, where such consent may be given with respect to specified suits or to several specified suits or with respect to all suits of any specified class or classes. A decree can be executed against such foreign state only with the consent of the secretary of the central government. The list of persons which cannot be arrested under this code are any ruler of a foreign state, any ambassador or envoy of a foreign state, any high commissioner or a commonwealth country, any member of the staff of a foreign state or ruler ambassador, where the request is made to the central government under subsection 1 of section 86. Central government may, refusing the request in whole or in part, give to the person making the request a reasonable opportunity of being heard. Section 87b states about the application of Section 85 and 86 to the rulers of a foreign Indian states, former Indian states, in the case of any suits by or against the ruler of any former Indian states, which is based wholly or in part upon a cause of action which arose before the commencement of this constitution or any proceedings arising out of such suits. The provision of Section 85 and subsection 1 and subsection 3 of Section 86 shall apply in relation to such rulers as they apply in relation to the ruler of a foreign state. Subsection 2 of Section 87b defines this section. A. Former Indian state means any such Indian state as the central government may, by notification in the official gazette, specify for the purpose of this section. B. Commencement of the constitution means the 26th day of January 1950. And C. Ruler in relation to a former Indian state has the same meaning as in Article 363 of the Constitution of India. Section 133 of Section Subsection 3 of Section 133 states about where any person who claims the privileges of such exemption and is consistently necessary to examine it is consequently necessary to examine him by commission, he shall pay the cost of that commission unless the party requiring his evidences pays such cost. Section 134 states about arrest other than in execution of a decree. The provisions of Section 55, 57, and 59 shall apply so far as may be to all persons arrested under this code. Section 55 Arrest and detention. Section 57 Subsistence allowance. Section 59 Release on the grounds of illness. Where Section 55 states about arrest and detention. Under the heading Arrest and Detention, a judgment debtor may be arrested in execution of a decree at any time, at any hour, or on any day, and shall, as soon as practicable, be brought before the court, and his detention may be in the civil prison of the district in which the court ordering the detention is situated, or where such civil prison does not afford suitable accommodation in any other place which the state government may appoint for the detention of a person ordered by the courts of such district to be detained, provided firstly that for the purpose of making an arrest such section no dwelling house shall entered after sunset and before sunrise, provided that secondly that no outer door of the dwelling house shall be broken open unless such a dwelling house is in the occupancy of the judgment and he refuses or in any other way prevents access thereto. But when the officer authorizes to make the arrest has duly gained access to any dwelling house, he may break open the door of any room in which he has reasons to believe the judgment letter is to be found, provided thirdly that if the room is in actual occupancy of a woman who is not the judgment letter and who, according to the customs of the country, does not appear in public, then the officer authorized to make the arrest shall give notice to her that she is at liberty to withdraw, and after allowing at a reasonable time for her to withdraw and giving her reasonable facility for withdrawing, may enter the room for the purpose of making the arrest. Provided fourthly that where the decree in execution of which a judgment letter is arrested is in a decree for the payment of money, and the judgment letter pays the amount of the decree and the cost of the arrest to the officer arresting him, such officer shall at once release him. Subsection 2. The central government may the state government may, by notification in the official gazette, declare that any person or class of persons whose arrest might be attended with danger or inconvenience to the public shall not be liable to arrest in execution of a decree otherwise than in accordance with such procedure as may be prescribed by the state government in this behalf. Subsection 3 states where a judgment debtor is arrested in execution of a decree for the payment of money and brought before the court shall inform him that he may apply to be declared an insolvent and that he may be discharged if the court has not committed any act of bad faith regarding the subject of the application, and if he complies with the provisions of the law of insolvency for the time being in force, where the judgment letter expresses his intention to apply to be declared an insolvent and furnishes security to the satisfaction of the court that he will within 1 month so apply that he will appear when called upon in the proceedings upon the application or upon the decree in execution of which he was arrested under the court may release upon he may release upon the upon the him release upon the direct security to be realized or commit him to the civil prison in execution of decree. Section 57 states about subsistence allowance. The state government may fix scales graduated according to the rank and race nationality of a monthly allowance payable for the subsistence of judgment debtor. Section 59 states about release on the grounds of illness. Subsection 1. At any point after a warrant for arrest of a judgment debtor has been issued, the court may cancel it on the ground of a serious illness. Subsection 2. Where a judgment debtor has been arrested, the court may release him if in the opinion he is not in the first state of illness to be detained in a civil prison. Subsection 3. Where a judgment debtor has been committed to the civil prison, he may be released therefrom a. By the state government on the ground of the existence of any infectious or contagious disease. B. By the committing court or by any court to which that court is subordinate on the ground of his suffering from any such serious illness. Subsection 4 of Section 59 states about the judgment letter released under this section may be rearrested, but the period of his detention in the civil court shall not be in aggregate exceeding which is prescribed in Section 58, which states about the when an amount involves exceeding 5,000 rupees, then a period shall not exceed 3 months, and when the decrees for the repayment of a money exceeding 2,000 rupees, but not exceeding 5,000 rupees, then the period of detention shall be 6 months. Thus, Section 134, arrest other than in execution of decree. Thank you for watching.